I was told that some of you couldn't hear me before, and I guess that explains why so many of you had such a happy look on your face. But I'll do my best now to be as audible as I can. So yes, this is the everyone's favorite topic, deductions. So I'm hoping that this presentation will address some questions or confusion that you may have, and I do have a stack of questions that when I get back to the office, we'll start working on trying to answer those and get an FAQ out there for you. But just a little bit of a primer here on deductions, exemptions, and credits. These terms do mean different things. There are different laws that apply to them. And I think I touched on this earlier, but a deduction reduces the assessed value that's subject to taxation. An exemption normally excludes a property from taxation and sometimes even assessment. And a credit is applied to a tax liability. The credit actually reduces the bill that's due. So the terms do mean different things, and part of it is just my OCD that drives me crazy when someone asks about a homestead exemption or a veteran's exemption. There is no such thing, but the terminology does have different meanings. They work differently, so it's important to have the right terms. And of course, I have to have my lawyerly disclaimers here. This presentation, other things the DLGF publishes are just meant to be kind of helpful or informative bulletins. They're not a substitute for the law. And we do encourage you to look at our most recent publications and memos because laws do change, circumstances change, and the most recent publications will be the most up-to-date and accurate. I know some folks have, keep memos literally for decades, and things can change and become outdated. Sometimes I'll have someone say, well, you said on page 5 of this memo from 2008, and that does happen. We try to correct, things or update things accordingly. Some of the publications we keep on our website are just meant to be historical records because sometimes you do have to know how the law read several years ago. But we encourage you to look at the most recent publications. And the last bullet point there, if you have any questions or doubts, please feel free to contact us up front. I try to be as responsive as I can and be as quick as I can in responding. Don't rely on third-party information or any rumors. Come to us and we'll do our best to help you. And also keep in mind your county attorney is a great resource. Sometimes, professionally and ethically, DLGF attorneys can't provide legal advice to other parties. So sometimes we'll refer you to your county attorney. And so that's a great resource to use if you need actual legal advice or counsel, or sometimes if you need an immediate assistance, your county attorney may be able to help you if they're located in the facility there. This slide, this is nothing new. This is from past presentations, but I thought I'd put it up front, move it up front this time. This is just kind of an overview of how a deduction works. State law does require that the homestead deduction is applied first, and then the supplemental homestead, and then all the other deductions are applied. State statute doesn't really dictate the order in which those other deductions are applied, but the homestead does have to go on first, then the supplemental, and then the other deductions. So as you can see with a deduction, we're just reducing the assessed value that's subject to taxation. All right, now, these are just some reminders. I think that I've brought these up before in past presentations, but the first bullet point, and we did touch on this in my new legislation presentation, if a deduction is validly in place on the assessment date, it will stay in place for that assessment date, even if the property changes hands and the new owner is ineligible for it. Again, exemptions come off during the same cycle for 14 and 15. All right, and again, that's why it's important to distinguish between deductions and exemptions. So, again, if I'm living in my property March 1st, using it as my homestead, 2 days later, I sell it to my cousin, or 2 days later, the bank forecloses on it. The deduction will stay on that property for that assessment date because it was validly in place on the assessment date, okay? For the next cycle, for the next assessment date, then the deduction would come off. Unless somebody else has applied for it in their name, then they would get the deduction for that assessment date, all right? Now, the second bullet point, there is a provision in the homestead deduction statute that says that if a person moves from their homestead after March 1st to a new homestead later that year, they can receive the homestead deduction on both of those properties for that assessment date. Now, as you know, normally a person can receive no more than one homestead deduction. This is sort of an exception to that rule. And again, it's someone who moves from their, I believe it would probably be an Indiana homestead after March 1st to another Indiana homestead later that year. For just that one tax cycle, they can get the deduction on both of those properties. Now, as there often is with the law, there's an exception to the exception, and that's the third bullet point here. And this is not a new change. This, I think, kicked in last year, as I recall. But if I'm moving from one homestead after March 1st to another homestead, and that new homestead was not completed on March 1st, maybe it was vacant land or just a partially completed structure, I can apply for the homestead deduction on that new homestead. However, if I do that, the homestead on the first property has to be canceled for that tax cycle. Now, I know it doesn't seem to make any sense. Why is there this exception to the exception? I'm guessing it may have just been an oversight by LSA or the General Assembly when they were putting this provision in place. Again, I can't make heads or tails of it. But again, normally if you're moving from one homestead to another after March 1st, you can get the deduction on both properties for that one assessment date. However, if the property you're moving to after March 1st was incomplete on the assessment date, and you're applying for the homestead on that new property, the homestead on the old property has to be canceled for that assessment date. Again, I know it's mind-boggling, but that is how the law reads. The last bullet point there, and before I move on, I do want to mention there was a recent Board of Tax Review decision concerning homestead deductions on partially completed dwellings. Now, I just talked about this legislative provision here that kicked in last year, I think for 13Pay 14, which would allow a homestead deduction to be placed on a partially completed dwelling. But you might be wondering, well, what about preceding assessment dates? What's the policy on partially completed dwellings getting a homestead deduction for preceding assessment dates? There was a very, very recent Board of Tax Review decision that involved an appeal. I believe a taxpayer applied for and received a homestead deduction for the March 1st, 2010 assessment date. The auditor subsequently realized the property was incomplete on the assessment date and pulled the deduction. Taxpayer appealed. Board of Tax Review said that a partially completed homestead can receive the homestead deductions. This is for preceding assessment dates. Now, as you'll recall, when I talked about the correction of error, that 3-year window, I think that would apply. I suppose somebody could file an appeal and seek a refund if their deduction was denied, if they applied within the last few years for the deduction and their property was incomplete. I suppose they could appeal and seek a refund, but again, that's that 3-year window. So that was a Board of Tax Review decision, not a DLGF decision, so please don't throw rotten fruit at me. We didn't come up with that one, but I did want to mention it to you. The last bullet point there, this is something that came up, a question about a party that fills out and signs a sales disclosure form, and they submit it December 31st, but they don't move in until the following January or February. Can that person get the homestead deduction even though they did file for it and timely submit the sales disclosure form? And, I think that our take on this was that the person probably should actually use the property as their homestead during the year for which they're applying for the deduction. So if you close on December 31st and sign the sales disclosure form, but you don't move in for another 2 months, it doesn't really make sense to get a homestead deduction for that preceding year since you didn't actually live there. You weren't actually using it as your principal place of residence. So just something to keep in mind when you get sales disclosure forms, that were signed that the person closed December 31st. If they didn't move in yet, that might be an issue. Just something to keep in mind. Moving on to some frequently asked questions. This first one concerns, this is a question I've discussed before. Can one spouse receive the over 65 deduction while the other spouse receives a veteran deduction? And the answer is yes. The same person can't receive both deductions, but one spouse or one owner could receive one, and the other spouse or the other owner could receive the other deduction. So the same property can have both deductions on it. It's just that the same person can't have both deductions. And when we updated the property tax benefits form, we did try to make that explicitly clear in case there was any confusion. Second point there, The homestead deduction applies to the dwelling and the surrounding acre, and that is coming from the homestead deduction statute. So if that acre overlaps 2 or 3 parcels, then those 2 or 3 parcels do receive the homestead deduction. I know that there may have been some belief out there that the homestead deduction applies on a parcel-by-parcel basis, so that if your dwelling is on one parcel, only that parcel gets the deduction. And technically, the statute speaks in terms of the dwelling and the acre. It doesn't speak in terms of parcels. So if you have 3 or 4 parcels within that acre, then all of those parcels would receive the benefit of the homestead deduction. And a reminder, that third bullet point, for 14 pay 15 forward, property has to be receiving a homestead deduction to get the 1% cap. You'll recall there was a Board of Tax Review decision a couple of years ago that said that property simply had to be eligible for the homestead deduction to get the 1% cap. And there was a legislative change last year that applies for 14 pay 15 forward. The property actually has to be receiving the homestead deduction to get the 1% cap. So just a reminder on that one. All right, now this slide, these are some oldies but goodies. The first bullet point there, some reminder, some refresher on the homestead verification form process. My understanding is that I think most counties are kind of wrapping this up, but just some refreshers here. If someone failed to file the verification form, the auditor may, in his or her discretion, terminate the deduction for the 12 pay 13 cycle forward. I think some counties are starting for 13 pay 14 to pull the deductions. That's fine. But to go back previous years, the auditor has to have an independent reason for doing so. So if a taxpayer failed to file a verification form, if the taxpayer comes in and provides proof of eligibility for the deduction, it has to be reinstated. And I'll emphasize that there is no deadline for the taxpayer to do this, and that is because of the way the law is written. The law does not impose a deadline. Theoretically, a taxpayer could come in 3 years and say, hey, you pulled my deduction for 13 pay 14. I was actually eligible. I've been living there for 40 years. Here's my proof. Give me back my deduction. And under the law as it exists, you do have to reinstate the deduction. The taxpayer could seek a refund. Again, I think they'd probably be bound by that 3-year window for claiming a refund, but there is no interest due. When you issue a refund for this purpose, there is no interest due. The other point I wanted to make is that there is technically no statutory obligation for the taxpayer to file a Form 133 correction of error. I know some counties want to do that for record-keeping purposes. I'm not sure if Board of Accounts has encouraged that or has suggested that. So I suppose if the county wants to have some kind of record or document for bookkeeping purposes, that's up to them. But you cannot tell a taxpayer who provides proof of their eligibility to get the deduction reinstated that I'm not going to reinstate it unless you fill out this 133, because you can't impose obligations that don't exist in law. So just something to keep in mind. Now, a reminder, second bullet point here, an auditor may limit what evidence he or she requests to a state income tax return, a valid driver's license, or a valid voter registration card. And that's true for the initial homestead deduction application. That's true for the verification form. Now, the auditor is not prohibited from requesting other types of documentation, but you may limit, if you want, what you request to those 3 documents. DLGF used to have an administrative rule that listed quite a few different types of documents or forms of proof, and for whatever reason that was voided by the General Assembly when they made this change in the law. But sometimes taxpayers will contact me and they'll say, I feel uncomfortable providing the auditor with my income tax return. It's got confidential income information on there. And what I tell them is, well, there are 2 options you might have. Either one, you could perhaps redact the income information on that income tax return, because for purposes of the homestead deduction, the auditor doesn't need to see income information. Or the taxpayer and auditor could perhaps work out some mutually agreeable alternative. Maybe there's some other document that the auditor would be willing to accept that the taxpayer could provide. Again, the auditor does not have to request only the income tax return, driver's license, or voter card. Those are 3 things that you may request, but you can request other types of documentation.
How do you know that you're getting all the W-2s if you don't know the total amount of income on the tax return?
Well, but again, it's not, the income doesn't really matter. It's where they're declaring their residence to be for purposes of paying taxes.
Right, I find that a W-2 is very important for that, because in order for them to falsify that, they would have to get cooperation from their employer. So I want to see all of their W-2s. Yeah. The only way I can be sure I'm getting all of them is if I can compare the total of the income
Okay. Well, again, you know, I think keep in mind, too, that the income tax returns are filed under penalties of perjury. So if somebody, you know, submits a return to you that's redacted and they say, this is what I submitted to the IRS, they're doing that under penalties of perjury, I think you could probably rely in good faith that, you know, this is what they declared. Yeah, could they be lying? But at some point, I think, you know, as the auditor, you may kind of have to, you know, make that leap of faith and say, hey, this person, you know, is risking criminal penalties if they lied, and I'm just going to rely in good faith on that representation. I still think that income information, I mean, I guess if you wanted to request all of the forms but tell the taxpayer, you know, I'd like to see all of them, but you can redact the income information, I think, you know, that would be fine. But, you know, again, or, you know, another option is just to work with them on some other form of proof that maybe both of you would be comfortable with. So, now, third bullet point there, if there is a dispute over eligibility for a homestead deduction in 1 year, that doesn't necessarily justify requesting multiple years of documentation. So if 13Pay14 is in dispute, let's say you have evidence that on March 1st, let's say February 28th, 2013, the taxpayer rented out the property. Okay, so February 28th was the first day of that lease. 13Pay14 is obviously in dispute. You know, unless you have concrete reason to go back prior years and say, I want to see, you know, several years' worth of documentation from you, I think you'd have to limit the request for information to the year in dispute. You know, this is sometimes what I call the shotgun approach, where, you know, if, you know, 1 year is in question, then I'm going to assume that, you know, multiple years are in question. So, you know, again, I think if 1 year is in dispute, you can request information for that 1 year, but to go back other years to request, you know, broader array of documentation, I think you'd have to have a, you know, a reason, a concrete reason for doing that. Fourth bullet point there. Sometimes I think auditors will, at the time someone applies for the deduction, they will request that certain documentation be attached to the application, and they'll refuse to accept the application if the applicant doesn't attach an income tax return or a driver's license or whatever the case may be. Just a reminder that when someone applies for the homestead deduction, they do not have to attach those documents to the application form. They do have to state the last 5 digits of their Social Security number on the application, but they don't actually have to attach documents to the application. So if someone submits the form to you and those documents aren't attached, you can't refuse to accept it because of that. If you accept the form and review it and you look at it and say, hey, you know, this form, half of it's blank, at that point, then you can go back to the taxpayer and say, hey, you know, you forgot to fill this in, or I need to have this information to process this. But you can't just outright reject the form because someone hasn't attached the documentation. You can't impose additional application requirements that don't exist in law. And the last point there, just kind of you know, helpful hint. This is some, you know, free tip for you. You cannot require submission of an entire Social Security number unless there is an explicit legal authority to do so. All right, moving on. This is a question that comes up occasionally. Unless a couple is actually legally divorced, if they're still legally married, they're entitled to only one homestead deduction. And that's true even if they're separated, even if they're living apart, and even if they completely hate each other, they're still entitled to only one homestead deduction if they're still legally married. Now, as always, there is an exception to the rule, and that's subsection N of the Homestead Deduction Statute. Now, I doubt that you'll encounter this scenario very often, but basically, if you have one spouse living in Indiana and the other spouse is living out of state, and they each own their own homestead property in just their respective names, then the Indiana spouse can get the homestead deduction even if the other spouse receives a homestead deduction in that state, okay? Again, this is probably a pretty extraordinarily rare situation, but it is just something to keep on your radar in case it does come up. And that subsection N kind of talks about what has to be done if that Indiana spouse wants to apply for the deduction. Now, this is a question that I received not too long ago. I thought I would share it with you here because I think it was worth discussing. In December, I received a letter from a taxpayer stating that they have moved and would like their mail forwarded to a new address. Should I pull the person's homestead deduction for the preceding assessment date based on that letter? And my answer to that was, well, I think we may need more information because it's not really clear if that person was ineligible for the deduction for that assessment date. As we've established again and again this morning, if a deduction is validly in place on the assessment date, it stays on for that assessment date. So in this case, if the family was living at the property on March 1st, and let's say they moved out of state in July, they would be eligible for the deduction for that cycle, and you would not remove the deduction. Okay, they're entitled to it, so you've got to leave it in place. Now, theoretically, is it possible that they had moved February 28th? Yeah, that's also possible. So I think in this scenario, the auditor would have two options. The first option would be either to err on the side of safety and just leave it in place in the absence of more concrete evidence that the person was ineligible, or if the auditor wants to do so, the auditor could try to contact the taxpayer and request more information. When did you move? And yeah, it is true that taxpayers are obligated to inform you when they become ineligible for a deduction. But in this case, we don't know if the taxpayer was ineligible. They may have been eligible, and so it wouldn't be right to pull the deduction to which they're entitled. And a reminder there, last bullet point, that a person can use an out-of-state driver's license to apply for the homestead deduction, either on the application or on the sales disclosure form. That is permissible. Obviously, if someone does that, you may want to follow up and just inquire, how long have you been living here, or how come you have an out-of-state driver's license. Keep in mind, I think that you have to get an Indiana driver's license within 60 days of becoming a resident here, if I'm not mistaken. So theoretically, somebody could close on a property on, a Monday in July and apply for the homestead deduction, use their out-of-state driver's license number, and then the next day go to the BMV and get their license, and that would be permissible. Some questions have come up recently on the income thresholds for certain deductions, the over 65 deduction and then the blind disabled deduction. And so I've copied the statutory language here. The over 65 deduction talks about the combined adjusted gross income as defined in Section 62 of the Internal Revenue Code of the individual and the individual's spouse, or the individual and all other individuals with whom the individual shares ownership or is purchasing the property under contract as joint tenants or tenants in common, cannot exceed $25,000. It's quite a mouthful. But what's important there is it's the adjusted gross income cannot exceed $25,000. Now, with the over 65 deduction, there is a provision in the law that requires the applicant to attach a copy of their income tax return to the application. So this is one time when you can require or demand that this information be attached to the application, and that is coming from state statute. The over 65 credit, and again, there's a deduction and then there's a credit for over 65. Speaks in terms of the individual who filed a single return, adjusted gross income cannot exceed $30,000. In the case of an individual who filed a joint return, combined adjusted gross income cannot exceed $40,000. Now, the over 65 credit, to apply for that, does not require that the income tax return be attached to the application form. Now, why is that? I don't know. That's just the way that the statute was written. The blind disabled deduction talks about the individual's taxable gross income for the calendar year preceding the year in which the deduction is claimed did not exceed $17,000. All right, now it technically doesn't use the phrasing adjusted gross income, but I think our agency over the years has advised auditors to consider the adjusted gross income. The blind disabled deduction has this additional caveat, which says, for purposes of this section, taxable gross income does not include income which is not taxed under the federal income tax laws. Now that caveat does not appear in the over 65 deduction or the over 65 credit. And again, why that is, it's just the way the statutes were written, 100 years ago. Now, I think what this is saying, sometimes people will receive Social Security income, for instance, that is not subject to federal income taxes. So I think if that's the case, if someone is just receiving Social Security income that's not subject to federal income tax, I don't think that income would count toward that threshold. I think that's what this is saying. And even though this phrase doesn't appear in the over 65 deduction or credit, I think by analogy, I think the same concept would probably apply, that only income that's actually subject to federal income taxation would count toward that threshold. I've listed here the lines on the different Form 1040s where the adjusted gross income is stated. If you have a taxpayer who comes in and tries to argue with you about, well, this is what my form says, but you should really deduct this income or add that or do this or that, DLGF does not oversee income tax laws or forms. It's a little bit outside of our wheelhouse. I might refer you to your county attorney to have that person come over and sit down with you and the taxpayer and look through that income tax return perhaps and evaluate what income counts and what doesn't. It's a little bit beyond our area of expertise, but again, I think the bottom line is if you're looking at adjusted gross income and you're counting the income that is subject to federal income taxation, I think that's what, what's really important. Now, moving on, a question sometimes comes up, do I have to notify a taxpayer before I terminate a deduction or if I deny a deduction? And normally I think the answer is no. There are two exceptions to that. With the homestead verification, before you pull someone's homestead deduction for failure to file the verification form, you do have to send them a notice. All right, and that's nothing new. We've talked about that before. This provision is also not new. This dates back to 2012, in fact. If someone submits a homestead deduction application to you and you look at it and you deny it, you are required to notify them of their right to appeal. And this is coming from state statute. So I think what's implied here is that you would have to send them some kind of notice if you deny their homestead application, and you have to notify them of their right to appeal. And I will note, obviously, send this to the taxpayer and not the mortgage company. I know sometimes the taxpayer is the mortgage company's address for tax billing purposes, but if you have an address for the taxpayer, send it to the taxpayer so that this doesn't end up going to the mortgage company if it's possible to avoid that. All right, veteran deductions. Oh boy, here we go. The code system. My understanding is the Department of Veterans Affairs has discontinued the code system. The code system was actually never a part of the veteran deductions. The codes, as I understand it, were used to classify vets based on their disability. But somehow they got conflated with the deduction statutes, and I think that may have caused some confusion. I would sometimes get questions about, I have a vet who's a code 3, so doesn't he get a $37,000 deduction? And I said, well, kind of hold on there, not necessarily. So I think what we need to do is look at the deduction statutes themselves and kind of move away from the codes as the basis for granting these deductions. There are two primary disabled vet deduction statutes. The first pertains to vets with a partial disability. This is a service-connected disability. The amount of this deduction is $24,960. And again, this is for vets who have a service-connected disability and who served during wartime. And it's a service-connected disability of 10% or more. The individual, the applicant has to either own or be buying property under contract. If the applicant is selling property under contract and the contract requires the buyer to pay the taxes, then the seller cannot receive the deduction. And this deduction can't be combined with the surviving spouse of World War I veteran deduction. So again, bottom line with that deduction, this is for partially disabled vets who served during wartime. They have a service-connected disability of at least 10%. The deduction is about $24,000. All right, so that's one deduction. The other deduction is for vets who are totally disabled or who are partially disabled but age 62 or over. The amount of this deduction is $12,480. And likewise, the vet has to own the property or be buying it under contract. If the vet is selling it under contract and the contract requires the buyer to pay the taxes, the vet cannot receive the deduction. What's important here with this deduction is to note that the vet did not have to serve during wartime. Okay, they simply had to serve in the military for at least 90 days. And they have to be totally disabled, it doesn't have to be service-connected, or at least 62 years old with a disability of at least 10%, and once again, does not have to be service-connected. The other big difference between this deduction and the one that we just spoke about is that this one has an assessed value threshold of $143,160. All right, so again, let me just recap. We have one deduction for partially disabled vets. These are vets who served during wartime. They have a service-connected disability of at least 10%. We have another deduction for vets who did not have to serve during wartime. They could have served during peacetime. They're either totally disabled or they're at least 62 with a partial disability of 10% or more. Does not have to be a service-connected disability. And the assessed value of their property cannot exceed $143,160. And the way the statute is written, it speaks in terms of the individual's tangible property. It doesn't say individual's residential property or homestead property. It says individual's tangible property. So I think this means that you would have to look at the assessed value of all of their property, at least their Indiana property. I had a question come up, well, what about a vet who owns something out of state, owns something in Florida? Do we have to count that toward this threshold? And I think the answer would be no, because the statute says, as shown by the tax duplicate. So obviously, out-of-state property is not going to show up on an Indiana tax duplicate. So you'd have to look at all of their property, real and personal property, to see if it exceeds that threshold. And again, why this one has an assessed value limit, but the other one does not, I don't know. Perhaps the idea was that this one, that the other deduction is for service-connected disabilities, and that maybe there should be fewer restrictions, and whereas this one is just for disabled vets. I don't know, but yes, you had a question. Right, and I'm going to talk about that in a slide or two. The vet is entitled to no more than one of each deduction, but the deduction can be split among properties if the vet wants it to be. When the vet applies for the deduction, on the application form there's a section where the vet lists the property that the vet owns. If the vet should list the property that he owns, not only so that you know what may exceed the assessed value threshold, but also so that the deduction can be split among those properties if he wants it to be. All right, this slide talks about the application process. There's nothing new here. Again, it's the same deadline for applying. The vet should apply with the auditor of the county where the property is located. And I think I'll talk about this in a couple of slides, but to kind of piggyback on that question, if a vet owns property in two counties and he wants the deduction split between those two properties, my suggestion would be that he apply with both auditors and make a note on the form, I've got these two pieces of property, I want the deduction split. And then the counties might have to communicate with each other to split the deduction between those properties. I think that might be the cleanest way to do it. But bottom line is the vet is entitled to no more than one of each deduction, depending on which deduction or deductions he applies for, but he's not prohibited from splitting the deduction. Now, in addition to the statement, the vet does have to submit information about the vet's disability. Again, this is another situation where you can require that certain documentation be attached to the application. And basically, this information concerns the vet's disability, so that the certificate's issued by the Department of Veterans Affairs, whatever proof the vet has of the disability. And that's nothing new. That's the same way it's been. Surviving spouses, there was a legislative change 1 or 2 years ago. A surviving spouse may receive these deductions if the vet satisfied the eligibility requirements at the time of his or her death, and the surviving spouse owns or is buying the property under contract at the time the deduction is filed. The surviving spouse is entitled to the deduction regardless of whether the property for which the deduction is claimed was owned by the deceased vet or the surviving spouse before the deceased veteran's death. And if a deceased veteran's surviving spouse is claiming one of these deductions, the spouse has to provide the documentation necessary to establish at the time of death the deceased vet satisfied the requirements. So I think that's referring to those disability certificates, that proof from the Department of Veterans Affairs that the vet, served, was honorably discharged and has a disability. Now, not to be irreverent, but if anyone comes into your office claiming to be a World War I vet, you may want to contact a paranormal expert. My understanding is that I don't believe there are any more World War I vets alive. I don't know why that statute is still on the books, but I guess maybe no legislator wants to, has the courage to, be seen as eliminating a deduction for vets. I don't know, but it is still on the books, but I'm not going to talk much about it. I will, however, talk about your favorite topic, which is excise taxes. Much ink has been spilled, and many computer keyboard keys have been punched on this topic. But basically, I think this is it looks worse than it really is. You have two groups of veterans. You have one group that qualifies for a disabled vet property tax deduction. And if one of those vets has that deduction applied to his property, and there's an unused portion of that deduction left over after it's been applied to the property, the vet can take that unused portion and apply it to any personal property taxes he may have, or if he doesn't have any personal property taxes due, he can apply it to excise taxes. And in that case, the auditor provides what I believe is the 128 vet form. I think Board of Accounts prescribes that. The auditor gives that form to the vet, and I think that form states the amount of the unused deduction or the credit that's available. The vet takes that form to the BMV, and then the BMV processes that credit. Now, if that vet, let's say that vet qualified for a property tax deduction, one of the deductions we just talked about, and he's used the whole thing on his property, there's nothing left over, there's nothing unused, then I think for purposes of excise tax credit, I think he's kind of out of luck because he's used the whole deduction on his property. There's nothing unused left over that he can apply to excise taxes. So that's one group of vets, and I think that's the way you guys have been handling that group of vets for many years. Nothing's really changed regarding that. You have another group of vets who do not own property or are not buying property that qualifies for one of the property tax deductions that we just spoke about. So I think in that group of vets, you would have vets who are renting an apartment, for instance. Okay, they don't own any property, they're just renting an apartment. Or I think you would also have vets who fall into that group who may not have a service-connected disability, so they wouldn't qualify for the partially disabled vet deduction. But their assessed value maybe is $500,000. Maybe they served in the military, they're totally disabled, but it's not a service-connected disability, and their house they live in, is $500,000. So they wouldn't qualify for either property tax deduction because, again, they don't have a service-connected disability, and their assessed value is too high. Okay, so those vets, the vet renting the apartment, the vet who's served, but his assessed value is too high, doesn't qualify for a property tax deduction. Those vets, I think, may qualify for this excise-only option. And how this works is the vet would come into your office and request an affidavit affirming that the vet does not own or is not buying property under contract that qualifies for one of those property tax deductions. And the vet would take that affidavit to the BMV, and I think the BMV has a form that they have the vet fill out at the BMV. So in terms of this affidavit, the DLGF did prescribe a template affidavit, which is available on our website. I have the web link if you need to access it. It's not an official state form, so you don't have to use this particular affidavit. If you want to come up with your own in consultation with your county attorney, that's fine. But we do have a template there just to be helpful. And affidavits do have to be notarized. So in this affidavit, all you're saying is you're simply affirming this vet does not own property that qualifies or is not buying property that qualifies for one of the disabled vet property tax deductions. You're not certifying credit amounts. You're not saying, okay, he gets $70 or he gets this amount or that amount. All you're doing is saying, hey, this vet doesn't own property or isn't buying property that qualifies for a vet deduction. And that does have to be notarized, so you might have to run down to your, court clerk or someone in your office who's a notary. Yes, you have a question. Mm-hmm. Yeah. Yeah, I mean, I think the statute just refers to an affidavit. It doesn't really specify, how it is to be notarized or if it's signed by the auditor, is that, a self-executing, signature or anything. There's nothing really in the statute about that. So, again, I hate to sound like I'm flaking out here, but I might just have you talk to your county attorney, get advice from that person as to, what your powers are and who has to notarize it, if anyone. So I wish I could give you a more concrete answer, but I think that's about the best I can do. So, all right. Let's move on to some frequently asked questions concerning the vet deductions. Can a vet receive more than one vet deduction? We talked about this already. The vet can receive no more than one of each deduction, again, depending on what he qualifies for. He could theoretically qualify for one or the other or both. It just depends. But he can split the deductions between or among properties. And I think in this slide we talk a little bit about that as well. The vet should apply in the counties where the properties are located, state the properties on the application form, and if he wants the deduction split, he should probably talk to the auditors about that. And by the way, getting back to that affidavit, when you're talking about the vet doesn't own property that qualifies, you might be asking, well, am I speaking in terms of just my county or am I speaking in terms of the state? I think you'd probably just be looking at the jurisdiction of your own county. I don't know that you would have access to other counties' records, so I think you would just be speaking in terms of your own county. Now, what about trusts? This is nothing new. Trusts can, a trust can receive a deduction if the person who has a beneficial interest in the trust qualifies for that deduction, and that's true for homesteads, it's true for veteran deductions. I'm not going to read that verbatim, but it is just something to keep in mind. What about a vet who has 5% interest in the property? His children have a 95% interest in the property. Is he eligible? Does he qualify? And the answer would be yes. I mean, 5% ownership interest is still an ownership interest. He doesn't have to be 100% ownership interest. It just has to be some kind of current ownership interest. Can the vet deduction be combined with other deductions? We talked a little bit about this before. A vet deduction cannot be combined with the over 65 deduction, which means that the same person can't have both deductions. The husband could have the vet deduction, for instance, the wife could have the over 65 deduction, that's fine. But the same person couldn't receive both. And just a reminder, the partially disabled vet deduction can't be combined with the surviving spouse of a World War I veteran. So, just in case, you never know. And the veteran's deductions can be claimed with the over 65 credit. Okay, not the deduction, but the credit is fine. And again, that's why it's important to distinguish the terms. Deduction, credit, there are two different things, mean different things. Now, what if two vets own a property? If two vets own the property and they're both eligible and qualify, they can each receive a full deduction on the property. That's not a problem. What if a vet only owns personal property? Can he qualify for the deduction? Yes. The deduction statutes talk about taxable tangible property. So if the vet just owns personal property, maybe he has some tools or equipment for his business, he can apply for and receive the deduction and apply it to that property. All right, very quickly here, I don't want to step on Andrew Berger's time here, but deductions on mobile homes. Oh, yes. I think it'd probably be stated in the certificate that the veteran supplies. I think that the vet would receive something from the Department of Veterans Affairs, and I think that certificate would probably indicate what kind of disability it is. I know counties usually have veteran service officers, I believe. You could always confer with that person if there's any doubt or any questions that you might have. I mean, I guess if you're totally disabled with and the total disability is service connected, and then I suppose you could qualify for both because you have a service connected disability that's at least 10% and you're totally disabled. So I think that would be that's the way that you could potentially qualify for both. If you only had like an 80% disability, you would qualify for the partially disabled vet deduction, but not the totally disabled vet deduction. So, okay, in the age, I see. Okay, yeah, I suppose that's true too. If you reach that certain age point, you might qualify then too. Yes, Martha. Okay. Right. Right. Mm-hmm. Yeah. But Martha's question was about, the vet qualifies for the homestead and the vet deduction, but when you apply both of them to the property, it doesn't really make much impact because of the circuit breaker. He's at his cap. And she's asking, well, since the veteran deduction doesn't really have any value on his property, can we just give that to him as excise tax? And unfortunately, I think the answer is no, because technically he's eligible for that deduction. It has to first has to be applied to the property, and then if there's anything unused after it's applied to the property, then that can be taken to the BMV. So, again, that might be a legislative thing, but let me just finish these slides, and I know I've got a stack of questions, and you'll have, you can contact me by email afterwards if you have any additional questions, but I just want to get through these last few slides. deductions on mobile homes. I'm going to skip right to this particular slide and talk about this. As you know, the homestead deduction, the amount of the deduction is the lesser of $45,000 or 60% of the assessed value of the homestead. But there's also a statute that pertains to personal property mobile homes, which says that the assessed value of a personal property mobile home cannot be reduced by more than 50% because of deductions, with the exception of the supplemental homestead deduction. The supplemental homestead deduction is not bound by that 50% limit. So how do you reconcile these statutes? Because you want to give the taxpayer the full homestead deduction they're entitled to, but you can't reduce the assessed value of the mobile home by more than half. So we have a scenario here: personal property mobile home with assessed value of $15,000, the land with assessed value of $5,000. We're assuming that they're owned by the same person. So the homestead on this property would be $12,000. That's 60% of the $20,000. All right. Now, we can't reduce the assessed value of the mobile home by more than half. All right. So half of the mobile home AV is $7,500. So we'll use $7,500 of the $12,000 deduction on the mobile home. That leaves us with $4,500 of unused homestead deduction, which we will apply to the land. And the land is $5,000 in assessed value. So that reduces that gives us a net homestead AV of $8,000, the $7,500 from the mobile home and the $500 from the land. Then you would apply the supplemental homestead deduction to that amount. In this case, that would be 35%, and that generates another deduction of $2,800. So in this case, the assessed value on the land looks like it'll be knocked out. Okay, we had $500 of outstanding assessed value on the land. We have the supplemental homestead deduction of $2,800. We're probably going to use some of that on the land, so the assessed value on the land is knocked out. There'll still be some assessed value on the mobile home. So we've been able to give the taxpayer the full homestead deduction that he's entitled to, and we've still been able to accommodate the restriction on reducing the assessed value of the mobile home by more than half. Now, again, keep in mind, yes, that the mobile home and the land are presumably two different parcels getting two different bills, but the homestead deduction speaks in terms of the dwelling and the surrounding acre. So even though you may have two parcels here, one's real, one's personal, you have to think of them as one whole for purposes of the homestead deduction and just kind of work out in how you calculate and apportion the deduction. And I think the last question I have here that came up a while back is our vendor software is set up so that if all of the VET's deduction can't be applied to a mobile home, we apply it all toward excise taxes. Is this acceptable? This kind of echoes Martha's question. And what we said is that, you know, if any part of that veteran's deduction can be applied to the mobile home, it needs to be. If you can reduce that assessed value of that mobile home by half, and then give the vet, you know, the remaining veteran deduction for excise taxes, that's fine. But somehow the software is going to have to be adjusted, or you'll have to manually override it so that that vet is getting the deduction he's entitled to on his property. So again, I've got a stack of questions that came up. I think there was one about the, is there a limit on the time we have to refund this? This is an ineligible homestead. What if they come in next year with a verification of homestead? Will we have to refund? And I think I did talk about that in my presentation, that there is no time limit for the taxpayer to come in. If they're within that 3-year window to request a refund, they can get the refund, but there's no interest due. So, but we'll look at all these questions and put them together and get them back to you. And again, my contact information, email is always preferable if you need to reach me. So thank you very much.